So, welcome to EJIL Live. At EJIL, we've always been very proud that we have not just gone to the big poobahs of international law, but over the years, we've always been keen to spot the most promising talent of the future. And very shortly, we will be publishing 25 years to EJIL. And as part of that package, we will have all the table of contents. And those of you who take a look will see how many of the most distinguished and interesting public international lawyers writing today in some ways started their career or their publishing career publishing in EJIL. And it's a great pleasure to welcome today Oisin Suttle, who is a lecturer at the University of Sheffield, but is still completing his doctoral dissertation at University College London. Welcome.
Thank you.
And I selected his article, which will appear in issue 25, number 4 of EJIL, the last issue of 2014. I find it exciting and challenging and a big correction to many of us working in the field of international trade, but also people thinking more generally about international justice. The title of the article is Equality in Global Commerce Towards a Political Theory of International Economic Law. Now, I think a standard course in international commerce or international trade law will at some early point teach a theory of comparative advantage and will claim to the students that liberalization of trade, promoting comparative advantage, in some way increases or enhances aggregate welfare so that everybody is better off. Maybe not everybody gets richer at the same pace, but everybody, whether developed countries, developing countries, if they engage in international trade, there will be enhanced welfare so that we can go to sleep peacefully, that we're doing a good thing for welfare and justice in the world. And that is one of the premises that you challenge in your article. And you say that there are serious issues of distributive justice, and in this context, distributive economic justice and distributive economic welfare that result from our international economic law regime. So maybe you can start and explain to our listeners on the podcast and our viewers on YouTube where the challenge lies, why this sort of nice story that we tell based on liberalization of trade and comparative advantage has a dark side.
Thank you. I think that's a question which I certainly challenge in the paper, but I think the heavy lifting of challenging it is done not by me in my capacity as a lawyer or a theorist, but rather by economists. And economists have been doing the work for 60 years at least of demonstrating that the case for comparative advantage, while strong, while generalizable, while applying in many cases, perhaps in most cases, doesn't cover all cases. So the case of developing countries has been the most prominent where this has been challenged. I mean, we see this if you look at a lot of the sort of dependency theory going up through the late 50s and into the 60s, campaigns for a new international economic order, arguments that from the perspective at least of developing countries, something about the way that the international economy was structured and was liberalizing was in some sense damaging or at least restrictive to their prospects for economic development. In terms of ideas that are more centrally part of the contemporary discourse of trade and particularly trade regulation, I mean, there are important ideas in terms of the terms of trade effects that different sorts of regulations, different sorts of tariffs, quotas, whatnot have. There are various ways that domestic regulations and border measures can not just restrict trade with the sort of negative efficiency effects that comparative advantage theorists focus on, but can also substantially shift where the benefits of trade are, so that we may still hold that in any given case the fact of trading may be beneficial for all, but the question of who benefits most can be significantly affected by how we regulate trade.
Just to clarify something. So one of the standard critiques of the system as we've set it up has been, for example, if we look at the WTO, that there has been widespread liberalization in industrial products, but very swinish behavior by some of the biggest producers like the United States and the European Union when it comes to agricultural products. So that the benefits of trade accrue mostly to producers of industrial goods, but where they could accrue in relation to, for example, production of agricultural products, the system shuts them out. But your critique is more profound, because it will say even in those areas where there's been liberalization, like production of industrial goods, there can be, even if on aggregate liberalization, there might be a case for the kind of liberalization which international economic law promotes, there can be distortive effects in terms of redistribution, who benefits, and where the advantages go. Maybe it would be a good place to give us a concrete example so that the listener or the viewer can immediately relate to it.
Sure. Well, again, starting with the development case, there are good stories to be told about the prerequisites for industrialization. And if you look at a sort of a very purist market economic analysis, we might assume that the capital required for industrialization could be found in the market. And if we apply efficient market hypotheses, we have reasons to think that that capital will find its way to the relevant opportunities. In fact, when we look at developing countries, we see incomplete markets, we see very limited supplies of capital, and so there may be a strong case for saying there are anti-liberalizing moves. There are cases for targeted protectionism, for subsidies, different ways to correct these sorts of market failures. So that's I think probably the most intuitively obvious case. But I think it's also worth thinking outside of that. In terms of trade effects, if we think about what tariffs do, tariffs restrict trade, and that imposes efficiency costs, and that's what the conventional comparative advantage story tends to focus on. We're all harmed by tariffs. But the other thing that tariffs do is they change relative prices, which means that the effect of a tariff may be that, whereas for individual consumers within a country, they may pay a higher price because they're paying a tax on top of the price of the good, for the country as a whole, the price drops because part of the cost of that tax is borne by exporters. So these are two quite different examples, but in both they're examples where the pure comparative advantage story, the story of an international harmony of interest, at least breaks down. And at that point, we can ask questions which are roughly of the form. Well, given that it does seem to be the case that there are gains available from international trade, from international cooperation, how are those gains distributed? Who's going to gain more? Who's going to gain less? And both in the industrialization case and in the tariff case, which can apply to industrialized or to unindustrialized countries, there are different ways that we could regulate the particular industry, the particular product, which, yes, will have effects on what the total welfare gain is, what the total increase in production is, but they'd also have effect in terms of who gets to capture more or less of that value. And once we have those sorts of distributive questions, simply explaining what we need to do in trade in terms of ideas like Pareto efficiency falls away, because we're no longer looking for how do we maximize overall value. We're looking for, from the perspective of individual agents, and those can be individual agents within an economy, or they can be countries as a whole. There are questions about how each agent may want to maximize value.
Still, help me and the listeners and viewers, even if it's stating the obvious. So, in scenario one, we're looking at a tariff. The tariff is applied equally to everybody. And what I'm asking you to do, this is not a challenge, this is a clarifying question, is how would the single tariff, which applies equally to everybody who's exporting to the country imposing the tariff, how does it have a differentiated distributive effect in terms of these third countries? Some
Sure.
benefit and some don't.
Well, I guess it doesn't have to be distinguishing between third countries, though it can be. But even just thinking about think about a two-country model. You have an importing country and an exporting country. Without any tariff, there'll be a certain level of trade, a certain level of imports coming in, and that will have welfare effects for the producing country, for the exporting country. With the tariff, a number of things will happen. The overall level of exports will fall, and that will, let's assume, have a negative welfare impact for the exporting country. Now, it may also have a negative welfare impact for the importing country, and that's the sort of effect that comparative advantages theorists tend to focus on. However, the other effect of that tariff is it's going to reduce the price that's being received by the exporting country. So let's think about this in terms of bananas. Bananas are something that trade lawyers spend a lot of time thinking about. If I throw a 10% tariff on banana imports, that's going to increase the price that my consumers pay for bananas, but it's going to reduce the price that my country as a whole pays for bananas, which means for a banana exporter, it's going to reduce their welfare. And so what you have is both efficiency costs, but also this shifting of benefits from exporter to importer.
In the two-country model, I think that's well understood. And the free trader is drooling at the mouth listening to you because you're making a strong case for no tariffs at all. Because if we use the example that you have used, we correct that by simply not imposing a tariff. But that's why I'd like to go to my previous example. I'm looking at an example when it comes to actual restrictions like quotas and tariffs to uneven redistributive effect among third countries.
Sure. Well, I mean, to make those most convincing, we probably focus, we can tell a story about bananas. Now, it's not a story about a uniform tariff. It's a story about a differentiated tariff. But much of the bananas dispute was essentially a dispute structured as a transatlantic dispute, but essentially a dispute between various banana exporting countries. And it was focused on the distributive effects that the European banana regime had amongst those countries, increasing the prices available for some at the expense of others.
But here again, the sort of WTO aficionado will say, exactly, he's right. Because what the EU, for example, was doing was in violation of the international obligation, because there's not only a drive to liberalization in the sense that tariffs in and of themselves are bad, even if in a two-state model, but if you're going to have tariffs, they have to be applied in a non-discriminatory way. So everything you've said so far seems to suggest that if the system would work as it should work, or as the free traders would want it to work, if there were no tariffs, or if there were tariffs and they were applied evenly and in a non-discriminatory way, does that mean that the unequal, the justice distribution issue goes away?
It doesn't, because I mean, even if we take that story at face value, and if we adopt the sort of policies that it prescribes, the result is not no distributive effect, the result is rather a different distributive effect. So, sticking with the banana case, if we move to a non-discriminatory uniform tariff, that has benefits for those who were previously adversely affected by the differentiation, but it imposes costs on those who were previously benefiting from it. So there isn't a story that we can tell in that case about the particular solution advocated by, as you say, the conventional free trader as being a solution that avoids any distributive effects.
But if there was no history of prior discrimination, if we're just looking at a situation of a tariff that from the beginning was applied in a uniform, non-discriminatory way. Does that take the problem away?
Well, no, because we continue to have the option. So there are a universe of different ways we could organize our trade policies. And not just our trade policies, our domestic regulation policies as well, but sticking with trade policies. There are a universe of possible options. Whether there is a history of discrimination or not, it might be that there's a good argument for discrimination, an argument based in justice, an argument that says there are good reasons why we should be conferring additional benefits on some groups rather than others. The fact that the non-discrimination point is sort of a natural focal point for people who think about this is a function of the efficiency story. It's a function of the story about comparative advantage. But if we think about it in terms of the distributive story, the idea that some may benefit under some regimes and some may benefit under others, it's not uniquely picked out on that story.
So in a minute we'll get to your development of actually the elements of the theory of international justice, sort of your translation of the Rawlsian model to the international sphere, but still sticking with the mechanics as we know them. Do I understand you correctly that you're saying that in principle, most favored nation principle militates against global justice in international economic law because it insists that everybody gets the same benefit, and you're claiming that some countries should be getting preferential treatment if we want to ensure a true international economic just system? Is it really a challenge to most favored nation?
I think it is at least in part a challenge to MFN. That said, I don't think that it, as a challenge to MFN in that form, it's especially novel. The claim that there might be some who have a claim for preferential treatment. I mean, we have a long history in the trade regime of thinking and talking and acting around preferential treatment. So the idea that some might have such claims is in no sense novel.
But usually it comes up in the context of free trade agreements where we give preferential agreement, say a free trade agreement between the Union and a developing country, we will have preferences given to the development. But it's not absent, but it's more frowned upon within the global trading system, the WTO regime.
Yeah, no,
so preference, I mean, there are preferences to developing countries even within the global regime, but they're not quite as common, are they?
No, I think that's right. And I think one of the upshots of the story I'm trying to tell in the paper is if probably a more extensive system of preferences, but even if not a more extensive system, at least a more respectable story about what they're for. Because I think one of the challenges that the system of preferences, particularly within the multilateral system, has faced, has been a concern that unless we can articulate a good story about what global fairness, global justice is, what it demands, how we identify what prescriptions flow from it, you end up with claims for preferences being perceived as illegitimate in some sense. Illegitimate in part because they're perceived as economically illiterate. They're perceived as a hangover from an ostensibly earlier phase of economic theory. Now, obviously, there are many contemporary economists who would strongly question the assumption that those older theories are of no value. But the other reason why it's perceived as illegitimate is that we don't have a good story about why these particular sorts of preferences are due to these particular countries. And so you get arguments running both directions. You get fairness-based arguments from developing countries pressing for particular special treatment, and you get fairness-based arguments from developed countries pressing for uniform treatment. And one of the points that I make early on in the paper is that this seems to be a problem for a justice discourse, a fairness discourse in the trade regime, that these sorts of tokens, justice, fairness, tend to be invoked on both sides of so many issues. So if we think, for example, about debates about trade and labour, and particularly trade and labour costs, we see fairness-based arguments on the part of countries with low labour costs, which tend to be couched in terms of development and sort of a global equality argument. And then you see fairness-based arguments on the part of developed countries with high labour costs, which tend to be in terms of whether it's fair or unfair that workers are forced to compete with cheaper labour.
Let me just ask for one more illustration before we move into the theory, and I should advise the readers that the reason I'm doing it is because the way the paper is structured, it really starts with the theory and then it moves towards the examples, but I thought it would be useful that we would have some illustrations in our mind what we are talking about and then bring in the theory. So we talked so far of border measures like tariffs or quotas, but you also have internal measures, regulatory measures, which are obviously part of your paper, where a state controls safety issues or quality issues, etc. And can you give me an example where, when we assume that such measures are non-discriminatory, at least facially non-discriminatory, and do not have a protectionist intent, where they can produce unjust distributive effects?
Sure. Well, one of the example that I discuss in the paper is the WTO, the US shrimp case. And in that case, what's at issue is essentially an environmental protection measure, but it's a measure concerned with the protection of a particular endangered species, sea turtles. It's, as you say, it's facially non-discriminatory, but it's concerned with the protection of sea turtles from fishing practices adopted by non-US fishermen. And that's a case that, given the argument I developed in the paper, it's a case where a regulation of that kind, I think, is at least potentially difficult to justify, at least without a number of additional factors. But focusing on this idea of the distribution of benefits and burdens, it's a good example because we can assume that a regulation of that kind confers some kind of benefit on the regulating state. And we can understand that benefit in terms of the satisfaction of a moral preference, perhaps, or the satisfaction of a preference for environmental protection, the satisfaction of a preference for the protection of a particular endangered species. So there are
So we're not talking about the preference to the importing state, an illegal preference where we can show that it actually protects the tuna industry in the United States, because there the law itself would say so long as the other country can achieve the same result, you should allow a different way to achieve the same result. You're saying that even if everything is kosher according to our standard trade rules and applying the exceptions under Article 20 and all the rest, there are still preferences in terms of moral sensibility or their interest in protecting an endangered species which other countries might not have or might not have with the same priority. Therefore it distributes also the economic effects differently.
No, I think absolutely. No, I don't want to prejudge whether or not it can be compatible with Article 20. But certainly I think what I would say is there's a clear justice question there, because
I'm insisting I want to take a case which complies with the rules that would be WTO clean and nonetheless raises the issue of global justice. This is the hard and interesting case for us, that even when you play by the rules, you might have serious moral issues of redistributive economic justice under the international economic law regime, rather than take a case where actually one of the countries is cheating because it's indirectly protectionist, etc. So we're not talking about this latter case.
Sure.
We're talking about a case where everything is by the rule and you still say it produces challenging justice issues of redistribution.
Well, okay, just to be clear, I think there can be justice issues of redistribution which are which exist within a case, but which need not require that the case be decided otherwise than it is in fact decided. If you want a case where the outcome looks wrong in terms of the theory I'm advocating here, I think there is an only slightly hypothetical version of the EU seals case, which is objectionable on that basis. It's slightly hypothetical because in the EU seals dispute, the EU's overall objective of the protection of public morals in the EU and or the protection of animal life outside the EU, and the idea that there could be a regime for that isn't actually directly challenged in that case. As you'll know, the case in fact focuses much more on the exceptions. But I think there is a good story we could tell, which says that the overall seal, the seal regime in that case, a regime which is concerned to, at least in part, protect seals from the activities of Norwegian and Canadian sealers, that the EU's pursuit of that goal and the manner in which it's done, namely through a compulsory regulatory regime, might itself be something that we would have serious questions of justice about. And they're questions about whether or not that regime is justifiable to the particular individuals and communities that it actively seeks to regulate, namely those outside of the EU territory.
Understood. So that basically the moral preference of the EU in the hypothetical of humane killing and animal welfare and all the rest creates a serious cost to the countries who are affected by the regulation or the import, etc. And it's not self-obvious that from a point of view of justice, the equation comes out at the end as just.
Sure.
So to move ahead, and both in your paper and in our discussion, so you raise the specter that, and you've already mentioned it before, that on so many disputes, the fairness argument is raised, and you are somewhat dismissive, at least because you say that in most cases when you scrape under the surface of this is unfair, you discover some special interests, some economic interest, etc., that are using fairness as some kind of moral excuse in order to get a variation of what would otherwise be the normal rule. But you instead, and now we get to the heart of the paper, you are putting forward to us a principled way in which, when we have the kind of situations which we now gave examples of, we can weigh the issues of justice and in a principled way say either we need to do something differently, or even if it has indirect or what at face value would see an unequal distributive effect, it would not offend a principled way of thinking about justice. So maybe you can introduce us now to the heart of your theory. What are the moves you make to enable us, to give us a toolkit to take justice seriously in the realm of international economic law? And always on the assumption that we are applying the rules of trade correctly, so it's not just the injustice that protectionism creates or that a tariff creates,
Sure.
as in the first example.
So what I argue in the paper is that our focus in thinking about global justice should in the first instance be on the sorts of measures that states adopt, rather than starting with the global trade rules. And the reason for that is that it's state measures that sort of bite in practice. In the WTO, we regulate regulation, but it's the sort of first order regulation that actually has the direct effects. And what I argue is that in thinking about global justice, we should distinguish between two sorts of regulations, two sorts of measures that states adopt. And the first of those I label external trade measures. And external trade measures I define as measures that pursue their goal specifically through the regulation of international trade. So the international is a necessary part of the story that we would have to tell about these sorts of measures in order to explain what they're for, what they're doing. And then I have a second category of domestic economic measures, which is essentially the residue. Measures that either are all about the domestic economy or perhaps are about economic activity generally, but don't have that sort of specific international focus. And what I argue is that the sorts of considerations that are relevant to assessing the justice or injustice of measures in these two categories are quite different. I suggest that measures in the former category, so external trade measures, are going to be just, are going to be properly regarded as just, only insofar as they pursue some sense of global equality. I talk about global equality of individual opportunity, but I think there are different views one could take about the appropriate sense of global equality, or insofar as they're justified under a relatively narrowly understood self-determination proviso. So the idea is there are really only two justifications we can offer for these sort of external trade measures. Either they're globally egalitarian in some sense, or they fall under, as I say, a relatively narrow sense of self-determination. Whereas domestic economic measures...
Let's stop there.
Okay, sure.
Let's pursue it. So give us an example of an external measure which fails the test and an external measure that finds justification under either of your criteria, either egalitarian or narrow definition of self-determination. But let's first start with an example of a violative measure which either does not pursue global equality or fails the self-determination test.
Sure. Well, I think there's a good story to be told that the regulations in the seals dispute would fail in the EU seals case would fail that test. If you think about the goals of the seal regime, there are two different stories that we can tell and the EU does tell about the goals of the seal regime. One of which is about public morals and one of which is about the protection from suffering, the enhancement of the welfare of seals. It's focusing on the latter part of the story first. It's clearly a story about if you think about the story you would have to tell to understand the EU seal regime as being one which would enhance seal welfare is a story about affecting international trade. It's about affecting the incentives that individual seal hunters have. It's about affecting this sort of international demand. There is no story we could tell about what the seal regime is doing, which is just a story about what's going on within the EU, as there would be if we were thinking about a safety measure, for example. So it seems relatively clear to me that we're looking at an external measure. It also seems relatively straightforward to see that it's not motivated by any sense of international equality. That's just not part of the story. So we then have the question of whether it falls under the sort of self-determination proviso. And to get an answer to that involves digging down further into how we understand self-determination, what the value of self-determination is.
Because the superficial case for self-determination, and this is all what I've learned from your article, would be to say, as part of our self-determination, we hold that our identity is as a moral society, and there are certain practices that we simply cannot tolerate. So in the same way that, for example, the WTO itself would allow us to restrict trade that is a result of slavery, we want to restrict trade which is a result of a type of cruelty to animals which we find inconsistent with our self-understanding, and our self-understanding is part of our self-determination. And you fault that. So why does that not work under self-determination justification?
I fault that because I think that sort of story is no different to a story that we might tell in terms of individuals that says, I find the sort of activities that you engage in, contrary to my self-understanding, abhorrent to me in some sense. And at least from a liberal perspective, and the whole paper is very much from a liberal perspective, we're committed to denying that those sort of concerns are an appropriate basis for regulation that restricts you doing something. They may be an appropriate basis for me to publicly express my concern, perhaps to discuss with you the fact that I'm concerned about the things you're doing, but they're not an appropriate basis for regulating to stop you doing that. This is a fairly straightforward central liberal idea, and I think a sense of self-determination that extends not just a power of criticism, but a power of regulation to what others are doing, to what's going on outside the state.
But where does one draw the line? Where does one draw the line? Because even under your own liberal theory, we would say that it's legitimate, for example, to say, I think children should go to school until the age of 16, and therefore I'm going to regulate internally child labor below the age of 16, and therefore why should I not also prevent international trade, take an external measure which would come from child labor below the age of 16, and all we're doing here is to shift the moral sensibility, not child labor, but welfare of animals.
Okay, so there are two different routes you might take at that point, I think. One is to try and tell a story which is still a story about self-determination. It's about choices that I am making for myself. But at that point, the story has to be one about what's going on within the state, within the community. Self-determination is a claim to live in, to have the sort of community that we want to have. And I don't think that can be a story about seal welfare. It can be a story about the sort of moral taint that attaches to members of my community if they engage in this sort of practice, which is a subtly different story. And the reason why it's interestingly different is that stories about protecting citizens from moral taint are stories that liberals are going to be committed to rejecting. I mean, that's a pure moralism. Liberals are only going to be able to get on board with regulation if it's about pursuing some reasonably plausible concrete goal other than the moral health of other citizens. So the other way we might go then to try and explain what we're doing in the seals case, like your example of regulating what my fellow citizens do with their children, is to say not this is self-determination, this is about me making a choice, but rather there is some external standard which is binding on all of us, which is the sort of story you will tell if you want to try and justify
What's the external standard that's binding on all of us?
Well, so for example, if you want to try and explain why you think it's reasonable for the state to force your fellow citizens to send their children to school, it's not going to be because you think they should do it. It's rather going to be because you think there is some valuable sense of autonomy, perhaps, that those children have a rights claim. And those values are going to apply whether or not you think they are the case.
But why is it that, in what way is that not transferable in the example that you yourself gave to a concern for animal welfare?
It's not necessarily not transferable, but the structure is different, because it goes from being an argument that says we, the European Union, think that this is a value and this falls within our self-determination, this is something we have a right to choose for others, to rather reclaim that there is an external standard and that is the one that we are pursuing. So you see the invocation of those sort of external standards in various earlier WTO cases that might fall under this. So you see them in shrimp. There's a great effort in shrimp to invoke the existence of an internationally shared standard in relation to the protection of sea turtles. And indeed, a concern to highlight the extent to which the complainants in that case were committed to that. If you can help yourself to that sort of international standard in the seals case, if you can show that there is an international commitment, that there are that the goal of the protection of seals is one which, in fact, is shared by or ought to be shared by exporting states, then maybe there's a justification you can make there, and that's going to fall under some sense of their self-determination. But it's still...
Just to make sure that I understand you correctly, because I'm not entirely persuaded, and maybe some of our viewers or listeners will not be persuaded. Because if we go back into the state, the external standard in relation to child education surely begins with personal preferences. And enough people develop a preference that children should go to school up to the age of 16 or 18 or the case might be. And at a certain point, provided it doesn't violate fundamental human rights of liberty, autonomy, or what not, but we're not getting into that, then it becomes a so-called external standard, and we even impose it on people who might think that there's nothing wrong in putting children at the age of 12 to work. But now you're saying that the seal thing would work. It's not enough that the European Union feels that in terms of their self-determination and their self-understanding of what a decent society should or should not do, or the kind of society they want to do, there has to be some international accepted external standard. But does that mean that how does that develop? Through some kind of treaty? What if you don't get that treaty? You have to put up with practices that are inimical to what you hold as immoral practices. Let's say that the WTO did not have an anti-slavery provision in Article 20. Would it not be possible for a country like the EU to say, regardless of what other countries think, we are against slavery or forms of gender discrimination, and we will not accept products which result from things that really go against what you call correctly, and I find powerful, our sense of self-determination. I'm not saying, and I'm not being polemical, I really don't see the principle by which the one, like child labor, and the other, animal welfare, one falls inside what you claim is justifiable self-determination, justification, and the other one outside, simply because there's not an international consensus on animal welfare?
So, to be clear, I don't suggest that either would necessarily fall within a self-determination justification from the point of view of an importing state. I don't. So the key principle is roughly the same one that we have domestically. It's one which respects the moral equality of others, including their capacity to determine moral questions for themselves. So that's sort of the background structuring principle. And it's the one that forces us to accept that whereas we may consider that the clubbing of baby seals is morally abhorrent, others may disagree, and we haven't succeeded in convincing them of the moral truth of the case. And again, this is an idea that many liberals will find very familiar. The idea that we have to respect the moral powers of others, their powers to make these sorts of decisions. So that's sort of the first step. In terms of
is the consequence in terms of policy, so I see the force of the argument. The fact that you have a certain moral sensibility and you dress it up as the right of self-determination should not be a mask simply by privileging your moral sensibility to the moral sensibility of others, which deserves equal dignity and equal respect. But I can see that, but if I now translate that to actually concrete decisions, is the only time I'm allowed to impose my moral sensibility, which derives collectively from, as you put it, from self-determination, in those instances when there's something close to a universal consensus on a moral precept?
No, because I think, and this is why when I started introducing the seal case, I distinguished the two arguments that the EU is making, one of which is about animal welfare, and one of which is much more about the sort of the domestic moral effects. You see this if you look at it's particularly clear in the panel decision in seals, less obvious in the appellate body decision. You see that these are run as essentially parallel arguments. And if you think about the argument invoking the domestic moral effect, I think there's a much more plausible self-determination argument there. And the reason for that is if you think about the sort of basis on which we justify self-determination, the sort of stories we tell about why self-determination is valuable. One of those stories, and I think certainly for these purposes, the most relevant of those stories, is one which says something like, it's valuable for individuals to live in a society in which they can feel at home, a society that is appropriate to them. And a lot of sort of cultural nationalist arguments for self-determination at some level invoke something like this. And if we buy that story, then I think there is a story that we can then tell about public morals, which understands public morals in terms of what's happening within a given society. Because if you buy a story like that, it can only extend to, it has to be valuable for me that the society I live in is a sort of society I can feel at home in. It can't be a story about how others should conform their societies to be ones that I can feel at home in. And so
Granted, but isn't the claim, okay, and you accept that it's legitimate for a society to say it's our own moral comfort and it's the kind of society that we want to live in, but that doesn't give us the right to impose that moral sensibility on others. But the world of trade challenges that strict boundary, because by allowing, for example, the entry of products which was a result of moral practices which we find abhorrent in our society, don't I become complicit in something that I import somebody else's moral sensibility that I don't share, and in a way they are forcing their moral sensibility on me by saying, we find that clubbing seals is not morally objection, that's our right, that's our self-determination. You can find it morally abhorrent, don't do it within your own territory, but the rule seems to be binary, that either side ends up imposing their moral sensibility on the other, because if I cannot pass the seal regulation, it means that they have the right to impose on me by forcing me to open my market to their practices. So I don't see that we get around the problem. We just shift. Instead of me imposing my moral sensibility on them, they are imposing their moral sensibility on me because they are requiring me to take these products.
Well, no. So I think this is why what you end up getting into is a question about the interpretation of measures. And I think that if the story that you tell about seals is a story about protecting the sort of the quality of society within the EU, allowing me to live in a state where I'm not exposed to these sorts of morally objectionable products, and so it's very much it's a story about us. Then you might be able to get along that line to a story which falls under self-determination. But in relation to seals, I make two claims. The first is the claim that I don't think that is an accurate story about what's going on in the seal regime. I think that the seal.
But if it were, it would be okay.
If it were, then I don't think it would be. I can't rule it. So sorry, I can't rule it out on this principle. If it were, I don't think it is accurate. I think that motivating the sort of regulatory intervention you get in seals is only plausible if we think that part of what we're going to do is we're going to reduce the overall incidence of seal mortality or of seal welfare impairment. And that's an empirical claim, and I don't bring any data to the table, but I'm hoping that many listeners would at least find that plausible. We're trying to do something. The other point which I think is relevant in thinking about this is that if we were simply concerned with protecting the moral quality of our own societies, it wouldn't necessarily be a problem on the principles I adopt here, which are principles about relations between societies. I think for many liberals, it would be a problem in terms of their domestic self-understanding. Because for many liberals, the idea that there is a power to regulate to protect the moral environment is itself going to be very difficult to square with how they think about justice and legitimacy domestically. I mean, if you think about principles like Mill's harm principle, they're going to have serious problems with a measure which is not, because to get by on this story, we have to say it's not a measure that's intended to protect seals. Because if it was a measure that was intended to protect seals, then it would fall under these principles. Rather, it's a measure intended to protect the moral environment. And Millian liberals and Kantian liberals and Rawlsian liberals are all going to find that idea quite disquieting. But that's obviously outside the scope.
Depends on the facts, because we make moral judgments all the time, and we impose our moral judgments on our society, even though they are moral judgments in a variety of areas, like we invade the family in the name of child welfare, and we invade the family in the name of gender discrimination, and rightly so. So I think that kind of problem for the liberal is not a black and white. We draw a line between some kind of moral sensibilities. It's you live your life and you let me live my life. But very, very often we have public regulation based on a shared sense, or this is just not the kind of society we want to live in, regardless of what your own moral sensibility might be. But maybe it will be helped if we go back to my first question. So maybe you can give us an example where we have an external trade measure and it imposes costs on others, and it would be justifiable under global equality or self-determination. Sure.
Well, the easiest example under a global equality story is going to be the example of special and differential treatment, and many of the measures which are adopted under special and differential treatment. So if you think, for example, about for practical purposes, effective exemption of a large number of developing countries from the practice of iterative tariff reductions, what you see is a permission to continue to impose and to maintain external trade measures, tariffs. And tariffs are, I think, centrally a case of an external trade measure, which is justified on a global egalitarian basis. It's justified very much in terms of the claim to economic development on the part of the globally less advantaged and perhaps the globally least advantaged. And a lot more in terms of preference schemes can similarly be explained on that basis. So much of what we think of as sort of the north-south issues in international trade law can be understood through this sort of egalitarian lens. In terms of something that would be justifiable under the self-determination proviso, I think the most obvious place that you see the self-determination proviso in WTO law is the provision in Article 20 for measures required for the enforcement of domestic laws. Because if we think about, again, what sort of claim self-determination...
20D.
Your recall is better than mine. If we think about the sort of claim self-determination is, it's a claim to govern ourselves, a claim to make choices for ourselves about the sorts of states, the sorts of societies we want to have. And
I think that's powerful and persuasive, but it begs a little bit the question, because there still is that line which I'm pushing you and pressing you to try and help us understand, because Article 20 also has in 20A public morality, which is an invitation of a society to restrict trade in a variety of ways, or to have an exception to the various WTO disciplines on the grounds of public morality. So in the past, the way public morality was understood was typically to restrict the importation of pornographic material. But today there's more and more a notion of a more robust understanding of Article 20A, that public morality can also relate not only to a morally offensive nature of the product itself, but also the morally offensive nature of the production of the product. But from our previous discussion, you seem to suggest that would fall foul of the justified self-determination argument.
Yeah, so I think that's right. I think that the sort of view I'm defending here cautions against an overly extensive understanding of 20A, which is why, as I say, I think that the seal regime in toto was not challenged in that dispute. I think had it been challenged, it seems pretty likely, simply as a matter of sort of legal prediction, it seems pretty likely that Article 20A would have been understood in a way, is to permit it. I think the politics of deciding otherwise would have been quite problematic. Whereas I think the view I'm defending here suggests that it should in fact be understood in a narrower sense, and closer to the sense that we see in US gambling, in China audiovisual, where in those cases, that provision is very much understood in terms of protecting life within the community. I think it's most obvious in the case of China audiovisual. It's a provision which falls very much in terms of the kind of story about self-determination that I was telling a moment ago. A story that says a big part of justifying self-determination is telling a story about maintaining things being the way we like them in our own societies.
So the point of contention that is left between us, which we might decide just to leave unresolved. Well, there are 2 points that we might decide to leave unresolved. The first is, where do we draw the line, as we do in domestic affairs, where do we draw the line in international affairs among moral claims which we say under liberal theory that's a matter for individual decision, not for collective decision making. You don't impose your moral preference on all society. So if there's no harm done to others, you are free to live the life you want according to your moral standards. You don't impose them on others. So, whereas in some cases we all the time impose moral preferences, and how do we draw that line internationally? But the second one, which is trickier, and your article made me think about it for the first time in a serious way, by taking a limited and restrictive interpretation of 20A. It's true that I am not imposing my moral sensibility on another society. And let's move away from how Seals was argued. We'll go back to the hypothetical
sure.
that you set up. So you say it's a breach of the self-determination justification to say, because I find clubbing seals, that's fine, but I should not impose it on others. But in effect, the way the trade system works, that means that they get to impose their moral preference on me because I'm obliged to open my market to their moral preference. So heads I lose, tails they win. I can't impose it on them, but effectively by my restricting my external trade measure, in effect, I'm allowing them to impose their moral choice on me because I'm obliged to take their products, the process of which I find odious. How do you get around that according to your theory?
I'm not certain I can answer that without essentially repeating what I've already said about this, the distinction between a measure which is seeking to protect the quality of life, the sort of the quality of the community within a community, and a measure which is seeking to change other people's behaviour. I think that's got to be a key part of the answer. The other response, which is one which I will confess has been troubling me somewhat in relation to this argument and other aspects of this argument, is the extent to which this argument ends up being implicitly deregulatory. That it ends up being not an argument against a particular type of regulation addressed at a particular external entity, but rather an argument against regulation generally. And I think I don't think there's anything wrong with to some extent, a morally rather than economically driven deregulation tendency. I mean, liberalism has a deregulatory tendency, but contemporary liberalism also finds a lot of space for regulation, as you said. So to find that the whole argument hangs simply on a hostility towards regulation would be troubling to me. I think maybe the way to clarify it further is to say, when we think about self-determination, we tend to think very much in terms of collective agents. One of the points I make in the paper is that there are sort of two faces to the state. There's the state as citizens understand it, and that's the state as a set of rules. It's many other things, but for these purposes, the state as a set of rules. And then there's the state as outsiders understand it. And that can often be sort of the state as a particular type of international relations theorist thinks about it, the state as unitary. And a lot of the stories that we tell about self-determination as the imposition of one person's preferences over the other, they seem really plausible when we think about the unitary state, because we see Europe chooses, Canada chooses, and then we're left with this question of which choice trumps which. Whereas if we think about the sort of the other face of the state from the point of view of the citizen, then that becomes much less clear, because it's in fact Europe chooses for individual Europeans, many of whom, by assumption because there's a market, want to engage in particular transactions, purchase particular products. Europe decides for individual Canadians. And so I think at that point, some of the symmetry involved in that sort of clashing self-determinations argument falls away. But it does, I will admit, it does end up sounding a lot like a strongly deregulatory position. I don't think it has to be, but I think that the fact of it having a deregulatory tendency is certainly there.
So could you, we talked until now a long discussion, but I found very interesting on the external trade measure, and which has negative redistributive effect and therefore raises issues of justice, and you explained to us the two principles, global equality and claims based on a limited conception of self-determination. Could we move to the internal measures? And with the internal measures, again, we want to talk an example. So maybe you can give us an example of an internal regulatory measure which fails the test, and an internal measure which, according to your theory of justice, is saved because of same criteria,
sure.
global equality and self-determination.
Sure. Well, so what I suggest in the paper is that, in fact, these are not the criteria that apply when we think about domestic measures. When we think about domestic measures, the standard that measures need to clear is actually quite a bit lower. It's a standard which is defined much more in terms of, and this is how we justify to outsiders. Obviously, there'll be a domestic theory of justice, but in terms of how we justify to outsiders, what I suggest is that domestic measures will be just provided they don't undermine the basic rights of outsiders or impair the capacity of other states to become or remain well-ordered, essentially effectively self-determining. And the upshot of that is that the vast majority of domestic measures, at least in and of themselves, are going to clear this bar. So if we think about product safety regulations. Product safety regulations are product safety regulations.
Yeah.
So product safety regulations are the most obvious examples of domestic measures. The story that we tell about a product safety regulation is a story we can tell without ever having to refer to anybody outside the state. And what I suggest is, in most cases, a product safety regulation will not, in and of itself, undermine the basic rights or self-determination of third parties. However, where that sort of justificatory provision does bite is that it may be that the whole complex of state regulations has that effect. So, I mean, our domestic regulations close off markets. They impose costs on outsiders in just the same way that external measures do. In circumstances where those outsiders are at that threshold point where, and when we talk about basic rights, we're probably mostly talking about basic poverty rights. So rights not to live in poverty, whether those are understood in terms of a right to health or a right to life or a freestanding right against poverty. There are many cases where we could tell a story which says if this state was organized differently, that might have positive effects in terms of those sort of threshold standards of basic rights and self-determination for outside states. So it's not a case where it's easy to point to individual measures. I mean, we probably could. We could probably think about. I don't have one off the top of my head, but I mean, there are. If we can identify measures which essentially shut particular producers out of a market in a way that very directly impacts on workers in a particular industry, such that they are likely to fall below these sort of basic rights standards. Then at that point, we could certainly be looking at those kind of measures and saying, there's an issue here. And we see that. I mean, we see that if we think about some of the provisions in SPS and TBT, which require regulating states to think about the impacts their regulations have on producers, and particularly thinking about those sort of north-south questions. We have examples where the trade regime is at least concerned to think about the sort of justice implications for those at the very bottom of our domestic regulatory choices.
So this is very important because we've moved, and you mentioned SPS and TBT, so we've moved from a regime when it comes to internal regulation which says simply the requirement of the regulatory state is not to discriminate. And we've moved to a standard which says no, even if the measure is not discriminatory, it can be excessive. You can achieve the same level of safety by a lesser restrictive measure. And if you can achieve the same level of safety by a lesser restrictive measure, then your measure is not justified. And we've also moved a lot, certainly in regional arrangements, but also in the WTO system, towards the principle of equivalence, which is measured specifically and implicitly in SPS and TBT. But now, if I hear you correctly, you would say that when the decision maker is deliberating a safety measure for a product, he or she should not only ask themselves, A, is it discriminatory? B, is it really necessary? Can one achieve the same level of safety? But to throw into the decisional hopper also what impact would it have on producers in other countries, presumably poorer countries, etc., and take that into account in the overall welfare or safety that is produced, taking that into account. So, but would we go more than that?
I think there's certainly an obligation to ask the question, but there may also be an obligation to act on the answer.
Even if that means a lower safety standard?
Yes, I don't think that I lose too much sleep about the possibility that if it is the case, and I think it probably is the case, if it is the case that the sorts of regulatory choices that we make, particularly in the developed world, have adverse economic impacts on those at the very bottom globally. Adverse economic impacts which mean that individuals don't enjoy very basic rights. I mean, we're not even thinking about the full panoply of international human rights, but very basic rights, rights to life, right, anti-poverty rights. If it is the case that our domestic choices have those sorts of effects, and if it is the case that a marginally lower standard for the quality of apples
not the quality, the safety.
Or even the safety of apples. I mean,
just to make the hard case.
Sure, no, absolutely. Or even the safety of apples at a marginally lower standard would have an effect in terms of avoiding some of those basic rights violations. I don't lose any sleep over that. And I guess that's sort of, because we haven't really talked about that, but that's sort of the part of what motivates the whole paper, the whole argument, is to say, when we think about economic regulation, there is a tendency, and it's a very strong tendency, and it's explained by many, many things, but there's a strong tendency to think, look, when we regulate for us. The people who matter are the citizens. And that's a function of the way we've thought about politics and justice for most of the period, from the Greeks up to the mid-70s in political theory, and probably the mid-80s into the 90s in political practice, which is that, governments owe duties to their citizens. Their citizens are the ones that count. And part of what the paper is saying is, well, no, look, when we regulate, we don't just regulate our citizens. Our regulations also can radically affect outsiders. And if we take seriously an idea like individual moral equality, which is, I think, an idea that we have very good reason to take seriously, then I think we have to recognize that we have cases where we're making choices that may confer very marginal benefits on our own citizens and impose huge costs on outsiders. Now, I don't suggest, And I think it would be wrong to suggest that the appropriate response to that is that every time any government regulates, it should be regulating in the best interests of the 7.1 billion of us. I think there are many reasons why that's the wrong conclusion, and a chunk of the middle of the paper is about trying to express that. But I think that there's a profound moral failing if, when we regulate, we give no weight, no concern to individuals outside the state, and as I say, particularly individuals at the very bottom globally. I don't think that we can do that and continue to say that we are regarding them as of equal moral value. We're clearly not.
So with that, I can totally agree. And in practice, it very often turns out to be the case that when we give very strict scrutiny to some of our safety measures which have these kind of deleterious effects on citizens in other countries, we discover that in fact they're exaggerated, they're excessive, the margin of extra safety they give is limited compared to the negative effect they have on global markets and of the less fortunate, the ones whose, as you say, the most basic rights are being valued. So at a minimum, it should be an imperative part of the decision-making process to take those kind of interests into account and not just to think of your own population. The hard case will be when you reach some kind of level of safety that you say, I'm sorry, etc. But in most instances, I think simply making that part of the decisional process as your advocate and giving it really strict scrutiny. Do we really need that? So we're reaching the end of our time, and I want to finish with one question to you, which you've already hinted at before. So I read your paper a couple of times, and what I thought of, so, in some ways, and I'm not sure that's how you intended it, but it certainly could be read in that way. The nomes of Geneva, the sort of architects of the WTO, might be thrilled by your paper, because in some ways, when it comes to operationalizing, on most issues they say that's what we think should happen. We think that tariffs are inimical not only because of efficiency, but because of their discriminatory and uneven welfare impacts. They say that when it comes to developing countries, the WTO does not frown on preferential arrangements. In a whole range of disciplines, there's an acknowledgement of preferential arrangements for countries which are less developed, which don't have the necessary apparatus to achieve the kind of standards, etc. And even in internal, definitely the traditional view is that Article 20A should be interpreted restrictively, that it should not be a wholesale license to simply impose your moral standards. And even when it comes to internal regulation, you gave the example of apples. The final decision of the appellate body in apples was that even though there might have been a risk to Japan, after all, nobody could come up with scientific evidence to show the path of the pathogen. They said, nonetheless, Japan should accept the apples because the impact on others outweighs the potential interest. Or Korea beef, it was the same kind of story. If you couldn't show a truly vital interest in having a regime that has that kind of inimical effects of others, then you can't keep it in place. So in a way, just as you said before, there's a little tinge of what you say, which is a push towards deregulation, a kind of Thatcherite story in international trade. But there's also a sense of the WTO gets it right. All the sensibilities that you bring are the sensibilities that I expect the Director General of the WTO would say, absolutely, that's the direction to go.
So I think that's fair. One of the points that I make early on in the paper is that I think one of the reasons why trade lawyers don't spend a huge amount of time reading the sort of contemporary political philosophy on global justice is because it's very hard to see what a lot of the sort of views that are being defended in that literature have to say to us as scholars focused on the trade regime. There seems to be this sort of radical lack of fit. So you get these very strongly egalitarian theorists who defend views which, regardless of the merits of their theoretical argument, simply fail to bite because they're arguments essentially against the state system as a whole. And those arguments just don't really tell us very much when we try and think about regulating trade within the system of states. So one of the concerns that I had in writing the paper was that I think any theory like this has to be able to speak to the trade regime as it is. The paper is part of a larger project which tries to articulate how we should understand large parts of the goods regime in terms of these sorts of ideas. And that project is not radically revisionary in terms of its conclusions. Nonetheless, I think there is an important value in the project, and the value is in terms of saying, look, there are lots of different ways we can understand the rules that we have. One of the biggest problems with contemporary trade scholarship, certainly from my point of view, is that we tend to understand those rules almost exclusively in economic terms. And we tend to criticize them almost exclusively in economic terms. And as a result, when we come to those sorts of forks, those sorts of hard questions of interpretation, the voices that are raised most loudly are the economic voices. And so I think being able to tell a story about the same rules but in different terms can have real impact in terms of how we think about those rules and how we think about how we progressively develop them.
My last question was not intended as a critique on the project. On the other hand, on the contrary, it was to valorize it. Because what we have in this paper is to take the argument of fairness, which is usually dismissed by economoid talk, or when we scrape, we find that it's just a mask for special interest, and to teach us how to think in principled moral terms on some of the big dilemmas of restricting trade, imposing regulations, both internally and with external measures. That's the reason why we were delighted to publish your article. That's the reason why we invited you here to EJIL Live. And this is coming out in 25/4. And I invite all our listeners and viewers to download the article. And it really merits very, very careful study. Thank you very much.
Thank you.